I recommend putting copyright notice on everything if you can. So then we have a lot of questions about who owns the copyright, especially if there's joint ownership or multiple people working on something or tag teaming working on something. So a lot of questions come up when you have a freelance artist is hired and creates a piece of art, or say a logo that somebody's going to use on their website. So hopefully there's a written contract, and the contract will say, I'm hiring you to create this logo, and when it's completed, I will own the copyright on it. Or, I'm hiring you to make this logo, I have the right to use it on my website, but you own it for everything else. That's nice. If there's no written agreement, you look to see, was it part of the job? So this is where it can get a little iffy. If you're a freelance artist and you do this for a lot of people and the person hired you to make a logo for their website, they probably own it, work for hire. The only way that maybe that wouldn't happen is if you're an artist who doesn't ever do graphic art and he saw your painting hanging somewhere and wants to use this picture of your painting on the website. Then you could say, I own all the rights, I'm just letting you use the painting for this. You don't own the copyright, I own the copyright. I'll give you a very limited license for this, even if there's no contract. But if you take away anything, please put things in writing. Please get a written contract, even if it's a one page. In Georgia, one page, your names, what you agreed to, and you both sign it as a contract. You don't need to be notarized, a written contract. I recommend it. Public domain, I still get confused about what's public domain. Basically, it's a work that the copyright expired. So in the US, published works before 1923 are fair use is in the code, in the laws, and they basically set forth these 4 principles that the court will look at to see if it's fair use. So it's the purpose and character of the use, the nature of the use, is it more factual or more artistic? The amount and substantiality of the portion used, like what percentage. So percentages do come into fair use. And the effect on the potential market. And the courts always look at number 4 above everything else. So they'll say, it's fair use. Did you take away potential profit from that artist by using that copyright? If you took away potential profit, then it's not fair use. Classrooms have a little more leniency on the maybe take away a little profitability. The kids don't have to buy the whole book. But if a teacher's using almost substantially the whole book, that's not fair use. They should have bought the book. So class handouts of short excerpts are fair use. Quoting for a news report is fair use. Not fair use. Using a photograph to illustrate a newsworthy story. Oh, this is interesting because the subject of the story is newsworthy. It does not make the image necessarily newsworthy. So when a celebrity dies, the death is newsworthy, but certain photographs of them are still owned by whoever owned the photograph. You can't just use it. But if a famous artist dies and you want to show a painting they did for a little bit, you can go ahead and use it as much as you want. Kind of odd. So here's some fun examples of parody. Parody is a famous fair use. So is that coming up? Annie Leibovitz was the photographer for Vanity Fair. And she sued the movie studio for copyright infringement. And the movie studio claimed fair use parody of the image. And they said they were making a social commentary. So this is one where they were commercial. They were making a ton of money off of it. Why was it fair use? Well, the court said they didn't use the exact image. It was a parody. It was promoting a movie. They didn't take any money away from Annie Leibovitz. If anything, they made her more famous. It's considered artistic parody. And I think the court kept coming back to the fact that no money was being taken away from Vanity Fair. No money was being taken away from Annie Leibovitz. So another similar one that is, this is Jeff Koons did a sculpture based on a photograph. And Jeffrey Koons told his people helping with the sculpture, make sure you capture their expressions. I love their expressions. So he was taking what is distinctive and artistic about the photograph into his sculpture. So the court said, this is not fair use, you should have paid a license to use that. So what was Jeffrey Koons was found to have infringed the copyright of the photograph holder. So what is infringement? Using a part or whole of the image without permission, or going beyond the scope of a license you were given, or adapting an image without permission, or asking another photographer to recreate the image. And that comes up a lot. Who is responsible for infringement can get kind of tricky. If, say, you do something for you're a web designer, and you do something for a company, and the owner asked you to copy a picture, and you did it, who's at fault? Well, in that case, you're at fault, but they're going to get sued first as the web owner, and then they'll sue you, and it'll trickle down. What if you didn't tell them you said you got the rights to a photograph and you didn't, it's your fault. What if he told you to copy something, then you can prove you were following directions, but I think you'd still be at fault for infringement, so don't let someone talk you into infringement.
Buffalo Soldier?
Yeah, Buffalo Soldier piece sounded just like this cartoon intro. So the court was trying to show that he had access, that he had heard it. And he's like, I don't think I heard it. I probably heard it. I don't know. So the court had to very diligently see if he had had access to this U.S. cartoon music. And then they have to show you actually copied it. So there is some steps for someone to prove that you infringed. So if you come up with the exact same idea for a photograph of somebody, and you can prove you never saw it, sometimes you can get out of the infringement. It has to be substantially similar also to what you're accused of copying. And this is where the courts will say, there's no fixed percentage, but we can tell when it's a substantial similarity. So one of the things I find interesting is the Sans Affaire, where the person who did the picture will say, well, there's no other way of showing that. So it wasn't, if you take a picture of this window, anyone who takes a picture of this window is going to look pretty much the same. And that's a defense to infringement. Mine is an infringement because of this Sans Affaire defense. So there's a famous case, can you see, it's looking down at the feet of a businessman who's about to jump off a building. And somebody had it as an art photograph on the bottom, and then a different photographer used it for graphic design in an ad. The court said this was not infringement. They said that it's an idea, you don't copyright ideas, and there's only so many ways to show a businessman jumping off a building. And they actually said, this is a frequently portrayed scene. So it wasn't a complete artistic copy. A similar case was for this ad on the right, the owner user instructed the photographer to copy. Said, I like this picture, but I want her to be business casual, I don't know. And so less formal, they wanted it less formal. And this was one of those Getty images. There's a website where you can get all these photographs. Well, they didn't get a license. They thought they were doing it different enough that they didn't need a license. In this case, the court said, no, you infringed, and you need to pay them for that. It's so similar. And the artistic element is the line in the sand, the way she's leaning. It's a copy. So how do you transfer a copyright? It's usually a license. You can give people exclusive or non-exclusive. You can give them rights to different parts of what you own. Like we talked about the distribution rights, the performing rights. It needs to be in writing. Yeah, especially if it's exclusive, it needs to be in writing. Every day artists are sharing work or selling work without a writing, but it's risky. So I recommend getting it in writing. That's my big takeaway. So there's different kinds. They talk about broad rights, subscription rights, and managed rights. So So a subscription right, if you put one of your photographs on a website where people can log in and get, like, you know, you're not giving exclusive to anybody, different people can log in and buy rights. Manage rights, when you give rights to someone for a very particular time period or use. These are just the lingo you'll hear people talking about when you're licensing your copyright. So why register? You don't have to register unless you want to sue someone. And you don't have to register until right before you want to sue. So it's very inexpensive to register, and I'll cover that in a minute. So sometimes it's good to register, but there's no need to. You own it. You don't need to register. You put your notice on it. There are some things you cannot sue for that happen before you register. So there's some infringement, willfulness, nuances that you might not get if before the time you register. But you can get money you lost. Somebody stole it, you lost money for that. You can still recover that even if you only registered your copyright the day before you filed suit. I think it's attorneys, what is this? Attorney's fees, statutory damages. If you can prove you registered before the infringement, you get more money potentially. Other kinds of fees you can tack on. So you can register groups of work, individual works. You can register giant 1,000 pages of copyright code, copyright.org. So there's a form, VA. Copyright.gov is where the forms are. This is the official US site. $45 per. It's very inexpensive to register. Do not just mail yourself a copy of something in a sealed envelope to get a date. It doesn't work. People say, they used to call it the poor man's copyright. It doesn't work. Don't do that. All you have to do is put notice on it. You own it. If you want to register it, especially if you're going to be dealing with maybe ASCAP or BMI, if you're going to be dealing with giant agencies, why not pay the $45 and register your copyright? You can do it all online. But then you have to mail in your sample or your specimen, and don't use regular mail, and track it. This is an area kind of new, the Digital Millennium Copyright Act. It's basically, you hear people complain about it a lot because it criminalized taking copyright protection off of a CD or off a DVD, off a game. So if you hear people talk about the Digital Millennium Copyright Act, that's technical ways to protect a copyright. Being removed is now a criminal law, and even if there's no actual copy, just disabling that technology is now a criminal act. So that's interesting. Don't do that. So this is, if you see, you're out on the internet, and you see someone has your painting or photograph and they're using it, what can you do to protect yourself? Well, people were trying to sue Google or sue GoDaddy or whoever hosted the website. So there's a law called the ISP Safe Harbor. And what that means is these people who host websites have a safe harbor. And what it says is if you tell them that somebody's infringing your copyright or trademark, we'll get to that, and you give them notice, they usually have a link given to the webmaster. If you give them notice, they have to remove it expeditiously. If they don't, they can be in trouble. But if they do, they are not to blame at all. They cannot be held as infringing. So a really good thing to do is to go ahead and do that notice. They take it down very quickly. I've done it. It's always down within a day. Then you have to contact the infringer, and you can either try to sue them for if you feel like you lost money, or you can just say, don't use my work without my permission. I'll give you a license at a nice rate. Or whatever you want to do. If you're like, oh my gosh, I don't want it used for that, I don't want to be associated with that business, you have the right to say, you cannot use that for that. But you can no longer sue the web hosting company unless they refuse to take it down, which they don't. So So basically, it's called a takedown letter, but nowadays it's just a link on their page. Goes to their registered agent. You have to say what work it is, what page it was on, why you're saying you own it, and then you sign it, either physical or electronic signature. So some formalities to what has to be on a takedown letter. So why should anyone here worry about copyright? I guess it's the money. That's all I can come up with. You don't want people to steal your work. You don't want to be accused of stealing when you're not. I would always mark your work, put your notice on it. If someone sues you and they have registered you, they can get attorney's fees, they can get those statutory damages we talked about. And now we know that even some things are criminal offenses. So it's good to pay attention to copyright when you're out there, especially on the internet makes everything very easy to download. So now I'm going to switch to trademark. And I'm going to hold questions unless anyone has a burning copyright question. This thing I just talked about.
Can I ask a question on works for hire?
Yes.
If an artist is donating work and the nonprofit says, well, we would like to pay for your materials, does that become possible?
That's a good question. Are they donating it to be sold?
Just to be used just for performance?
In a performance. So the lawyerly answer is it depends.
Okay. Get it right, right.
It'd be really nice if it was on writing. If it's not, if you're someone who generally does that as your job, I generally sell this type of work to these kinds of people, then it's work for hire. You know, unless you can show that this is different in some way, then it's work for hire. That's the default. So that's tricky though.
Yeah, it's tricky.
So if you don't usually do that kind of work, but they bought your materials, then it's really tricky.
No, they usually do the work, but they want to keep the work afterwards.
Get it right.
But it was.
I had another work for hire question.
Okay.
Is there any specific, do you have to get like a work for hire agreement before the work is produced, or can you do it afterwards?
It could be afterwards. If it's in writing, both people sign it willingly, that's very valid. Like, oops, we should have put this in writing, we both agree this was X, Y, Z. The trouble is, you come up to the person after. Service marks, if someone does a service, they don't sell a product, they get a service mark. In the US, we call them all trademarks. Some countries really separate out what's a service mark. So here you'll see an SM in the US or a TM. We use an interchange, we use a service mark because it doesn't mean anything. But we also trademark sounds and colors like the Tiffany blue, the THX sound that comes up with being a movie, that's trademarked. The shape of a building, the way the Lamborghini door opens is a trademark, which I think is really weird. That one I would have guessed. And the shape, I had a friend who was involved in a Sharpie marker trademark suit, and it was the gray barrel. Somebody was trying to do a knockoff permanent marker, and they used a gray barrel. And Sharpie's like, nope, we have trade, they call it trade dress. We own that trade dress, look it up. They won. Burberry's plaid is trademarked. Then you'll also see things called collective marks, which is a group, an organization, and certification marks. And those are interesting because the company doesn't use them. What they do is they sell you, then you get to be a certified copy, and then you get to use it. That's a way to make money, is to be a certification organization and license out the use of a trademark. So there's a difference between a trade name or a business name and a trademark. You register both. Trade names are usually registered for a geographic region, like state, or like region, like the EU. Trademarks then would be what identifies the goods or services. So, for example, Coca-Cola Company owns Coca-Cola Sprite, Dasani. Lots of trademarks under one trade name. The function of a trademark tells you the source of it, and what's really worth the money is that it becomes goodwill and quality. That's when a trademark's really valuable, is when it has lots of goodwill and quality assurance in the brand awareness. So to get a trademark, they tell you to do 3 steps. Select your mark, clear your mark, and then protect your mark. Select your mark is, I like these words, it's distinctiveness of the mark. So the totally generic mark, if you have you call it perfect cleaning company, and you're not going to be able to trademark that. The trademark office is going to say that's too generic, owner, the combined word term. So it's something you can go online for free and just play with for hours and search, see what's trademarked.
What's it again?
USPTO for US Patent Trademark Office.gov. I think we're going to give the presentation, we can email it to people, is that correct?
We're also planning on having it linked to.
And it'll be
the-
online. Okay. So this is the select, clear, protect. This is the clear part where you're searching to see. If you go on there and you find someone already has it exactly for what you wanted it for, then you're not going to be allowed to own it. Something I wanted to, I'll get to it. So you register in the U.S. office. Then there's this, you have to also register for foreign rights in the country you want to do business, or you can register with the Madrid Protocol, where member countries all have agreed to recognize each other. Or you could just say, I'm only going to use it in the U.S. and the EU, then you just register in the EU. There's different ways to do it, but it's easy. It's all online, it's easy. So you don't have to register, just like with copyright. Although it's more recommended, because usually trademarks for a business. You can own the common law right to a mark. If you use a mark in commerce, you own the rights to it. You can even sue people for infringement, even if you've never registered your trademark. You can sue them for infringing because you've used it in commerce. If you can prove it. Business card, you have a business card with that logo, you've used it in commerce. If you've handed out that business card to potential customers, you have used that logo in commerce. But if you try to sue someone and you haven't registered, you have to prove that you have the rights in a very strict way. So registration, they call it, gives you a presumption of rights. You don't have to prove anything, I own this. Here, I own it. Here's my trademark registration number. But in common law, it's only for the geographic region where you used it. That's where you own it, and you have to prove the use very strictly. So once again, it's safer to register it. It's not that expensive. I think I'll get to the price. It's like $300-ish online. It's $300 per category of classification. So there'll be. If you wanted to have it for T-shirts and literature and something else, you'd pay $300 for each type of international classification that you registered for. So, are you able to register? If it's not generic, it's not immoral, then the U.S. Patent Office will take it. Then they'll compare it to other marks. And they'll say, is this identical to something else? If it is, and it's in the same classification, then you might be denied. But then the famous case about that is Domino Sugar and Domino Pizza. They're both food, but they were allowed to coexist. The U.S. Patent Office, Patent and Trademark Office said there's no likelihood of confusion on the part of the consumer. They had different logos. I guess Domino Pizza came along 100 years after Domino Sugar. There was no confusion, so pizza was allowed to get the same name. Then you have the application procedure. So you've registered, the Patent Office compares it to what's out there, and then they go forward with the registration, and you can register it as an intent to use. I don't think I have a slide on it. Or it's already in use. They're both easy, and it doesn't cost more later, I don't think. There might be a $100 filing fee for. So what you have to do is you file an intent to use, Then later, you have to say, now I'm using it, I think it may be another $100 to show specimen of use. If you wait till it's actually used, you do one filing fee, you submit your specimen, you get your trademark if it's approved. So they don't like, they used to approve everything, and now I'm finding they're complaining a lot more. They're saying, no, that's too descriptive, that's too generic. They think we have too many trademarks. So a fanciful mark, a logo is especially easier than words. But a word mark is broader. So if you get a word insight for something, then somebody can't use that word in a logo. You protect the word and the logo. If you own the logo, fanciful picture, then you only own that picture of it. You don't own the words in it as much as if you own the word mark. So it's best to own the word mark, but it's more difficult to get through the patent office, patent and trademark office, if it's considered descriptive or generic. If that makes sense. So what you'll see on people's marks, the R in the circle means it is a registered trademark. It has been given a registration number. It was approved by some jurisdiction, say the US. TM and SM means either I've applied for a trademark and I'm waiting, or I'm claiming ownership to the common law trademark. So trademark, you can use a TM even if it's a service in the US. You can't use the SM if it's a product, apparently. We were talking about how copyrights end after so many years. Well, trademark, if you do everything right, you can keep renewing it, keep renewing it, keep renewing it. It's not going to expire unless you do something wrong. So some of the things you can do wrong is, I'll get to genericide, that's my favorite one. But if you failure to police, if there's all these people using it and you've never sued anyone, you've never written a letter, and then everyone else is constantly using it, a court can say, no, you slept on your rights. You don't get to own it. For 20 years, you let everyone just use it. Now you want to sue somebody. We're not going to do that. That's very common. If you fail to renew, they'll send you notices. Then of course it expires. And if you don't use it, when you renew, you have to prove continued use. So this is something that comes up at my company, is we'll have an old product name, and they're like, oh, we want to keep owning it. And I'm like, well, then show me where you used it. And they're like, oh, we don't use it at all anymore. We just don't want a competitor to use it. I can't renew it. Because you have to prove, in the US, you have to prove continued use to continue to renew the trademark. Did I say something? So here's my favorite one, is genericide. When a word gets so commonplace in the language that the court says you don't get to own it anymore. So like escalator, dry ice, cellophane, and linoleum. Escalator was a little different because I think I read it had something to do with World War II. But I got this picture offline, so I'm using it for fair use, educational purposes. But what's interesting about aspirin is in the US that was decided to be generic, but Canada, Brazil, it's still owned by Bayer. No one else can call their product aspirin. They have to call it, acetylsalicylic acid. So that's a bummer. But so to avoid genericide, you probably won't have this issue, but I think it's kind of interesting. So here's the companies that are trying very hard right now not to have generic terms. Kleenex, you'll notice that our commercials are Kleenex tissue. Band-Aid is one of the, a Band-Aid bandage. Band-Aid brand bandages. They should say over and over. Dell computers. So don't use a plural, like 2 Dells. You're going to lose it if it just becomes a generic. Or Post-it. Post-it note, if you say it's the Post-it's quality, don't make it possessive. So what Post-it note will do is if you go to their webpage, it's a Post-it notepad, something. And Xerox almost lost it because everyone was saying, well, I'm just going to make a Xerox of this, I'm going to Xerox this. I think they still own that when it was touch and go. And proper spelling, I don't see many risks with this, but H and M. You have to use it the same every time to own it. So that's it. So now I can answer questions. Yes?
This is mine.
Okay. It is a photograph.
It's my vegetables in my picture. When I looked at it, I liked it. And so I started making my postcards and my business cards. I don't know whether it's a logo or, you know, I don't know how to use it really, but I use, but it's mine and I use it for.
Okay. It could be multiple things. So
Multiple things.
first, when you took it, the
Yes.
minute it was fixed, you owned the copyright.
Right. And it's on my CDs, my
Right.
DVDs, it's in my camera,
Okay.
I'll read it. And I just made cards and I have postcards as well. And then my printer sent me samples of showing me how it would look on tote bags. So I went ahead and ordered some tote bags and it looks good. I don't have any words to it. At one time, I had my little copyright C there, but then it messed up, like you were saying.
Yeah.
I don't want it in the middle of my
Right.
picture, right? So, how can I trademark, copyright it, or?
So you could do either. I mean, it could be a trademark logo. It sounds like if you're going to put it on a bag, I mean, I don't know if I can't really give you legal advice tonight.
Yeah.
But, you know, it seems like if there's a picture, you don't have to put the copyright notice in the picture. It can be down below. It can even be like several inches below.
Yeah.
You know, that would be my recommendation, but I can't really give you legal advice tonight.
So is it copyright or trademark?
It's both.
It's both.
The way you're using it here, I would say copyright.
Yeah.
If you're going to start using it as your logo for your business, so if you made a flyer and say, I sell all these different kind of pictures on tote bags, but up at the corner, you always have that picture for your business,
Yeah.
then you could file it as a trademark. Even if you just use it that way, you own the common law trademark, you don't have to pay the money
Yeah.
unless you're afraid somebody's going to steal it.
Well, I have the original because I
Yeah,
have it.
right. So I think it's very safe.
Yeah, I mean, I just put it on everything, because I love it, you know. As more and more I
It's
see
beautiful.
things coming out of it,
Right.
I had no intentions, was just off the vegetable sitting on the ground and took the picture, and that's what it came out.
I think that's awesome. Yeah.
One more thing.
Okay.
I have a name. I was trying to get,
For your name,
I was trying, no.
oh, a company name.
Yes, I was
Okay.
trying to get a company name, and then when, what do you call the people who holds thing in the computer for you, when you're buying like a web,
Domain.
the domain,
Oh, okay.
right, domain.
Domain name.
Right, so, my magazine is Jim Root. So when I wanted the name spelled right, I guess I couldn't use it because somebody was using it, but for an art, for a movie, nothing to do with my food, mine is for food. They're holding the name for me, but we went ahead and spelled it differently, so as not to.
Yeah, that's interesting, because domain names,
Mhm.
yeah,
Yes.
the only way you can kick someone off of their domain name is if you can prove that you own the trademark
Mhm.
beforehand.
Yeah,
Well, even if the US government gives you that trademark registered to you, you can take it to the IIAC and say, I own this trademark, they're infringing my trademark with this domain name. If they've had it for decades, I don't know and if you just registered your trademark, I don't know if you'll get it. But if you own the trademark first, I know definitely you can kick them off and get it.
Yeah.
In this case, I don't think you'd be able to kick them off, so I think you might have to use the different spelling. I don't know.
right. Well, I went ahead and spelled, and everybody that I showed it to like my spelling
Yeah.
better. But I'm paying yearly for this domain name.
Right.
Will I ever be able to stop paying? Once I start using it all over, I don't have to pay for a domain name anymore.
Well, I think, you're not paying for the name, you're paying for the
They're not hosting.
They're not hosting a site.
No, it's just sitting there. But
Does anyone know? I don't
What?
know.
Yeah, there's an annual registration on domain names.
Just on owning the name.
it's sitting in my domain. It's my name.
So like networksolutions.com, they can hold the
Exactly.
name and not do anything else. You have to
Well,
get someone
typically
else.
someone who does that for you, if you don't choose to start your own website, they have a page that says this page is being held for So if someone goes to that name on the web,
I've seen
let's see a
that.
generic page like that, but yeah, you do have to
Pay.
register
Okay,
annually.
because I know that I have a website, and I do have paid network solutions, and I think you're right, I think I also pay a hosting service separate.
Yes, it's two separate things.
Okay.
What I'm thinking that as soon as I start using it on my magazines and everything else, then it's mine, because I'm the one who made it up.
Yeah, oh, if you made up a fanciful spelling.
Right.
Yeah, right now you have the common law ownership of it.
Right, and then they're hosting, they're keeping it in the domain for me.
Yeah, so you do have to keep paying, I
So I,
guess.
yeah,
You don't ever own it without paying a monthly, yearly fee.
You have to register it every year.
Yeah.
every year.
Any other questions? Yeah.
I have a sort of practice of law question. You mentioned that for trademark rights, you had on your slide, you mentioned something about common law rights. What's
They do separately. But for federal registration, gives you federal. Now, common law, my understanding is, and I'll turn this over, my understanding is common law, you only own it in the geographic region where you've used it. Now, I don't know if that's covered by state or federal, does anyone know? David, do you know?
It's state at that point, state common law claims.
Just in the small jurisdiction.
But
The
but
state
if
jurisdiction.
if you're selling on the internet, then your geographic reach is now the whole country, or maybe even further. So your common law rights could be bigger than your little region.
That's true, that's a good point. Now the internet made it nationwide or global. So that's interesting. But I think, I don't remember seeing federal common law rights. So I think it's.
Well, 1125 is 15 U.S.C. 1125.
Common law federal right? Okay. So it's just a trademark right, that you have registered. I like that, okay. Yeah?
Okay, I have two questions that are kind of related. I'll ask the first one first, but it'll inform the second one. So, we've all heard of bootlegging. So if you go to a concert and you've got like a recorder in your pocket and you record the show and then you try and sell it, that's considered bootlegging and is illegal, correct?
Yes. Unless they posted notices that said, go ahead and make a recording, which some artists do.
Right, so I'm wondering, first of all, why specifically is that illegal? If they own the copyright in the composition and their performance, but you're the one who's fixing it in the medium of an audio recording, why is that illegal?
It's a good question. I would say that you're not doing anything but recording a master recording of their copyrighted performance. Maybe if you took it and altered it in crazy artistic ways, you could claim ownership of that. I think you'd still pay them a license for the base master recording, right?
Sure.
It's a tough one though, but you, go ahead, Dave, you have some ideas on that?
Well, I thought, copyright is really the right to exclude others. So you can have a copyright that's sort of like a blocking patent, the same way that blocking patents work. They could have a copyright in their song, and you would own the copyright in the recording of their song, but neither of you could use it without cooperating with each other.
So, yeah, but I think if you didn't change it at all, I don't think you could say I own the copyright of the bootleg. I don't know, that's a tough one.
Is there such a thing as a right of first use with
Yes.
copyright?
This is always a tough one. I have that in patent law too.
So if you got your little
That's-
iPad
yeah.
thingy and then
Okay, so here's how I think of right of first use. If I write a book and I sell you a copy of the book, I'm selling, I get money for you buying my book. Now then, you have the right of first, but can you sell that book to someone else? Well, yeah, you can sell a used book, but you can't sell copies of it. You can't make money by mass producing it. So is that the right of first use? I'm the only one who can make mass copies of it. You can sell your little, so you buy an album, you can go sell the used album. That's the extent of my knowledge of right of first use.
what if you're performing a musical work publicly, ongoing, several people hear it and say, well, that's really good. They take off and they record it and they start publishing and selling it on their CDs.
A cover, they cover the
They
song?
cover your song. My understanding was you actually had the right to say who does or does not perform it
Yes.
first, cover, or that you would say
First.
yes.
That's
But-
interesting. Maybe that, I don't know, it seems like for that Harry Fox agency I mentioned, I didn't know there was a first use. I think it's sort of, it's like a flat scale now. That's
That-
interesting.
That may seem somewhat academic, but if you're a budding
Yeah.
songwriter, you're going to all these songwriting groups and swapping ideas. And stuff,
Yeah, yeah.
And
And you definitely own the publishing rights. Someone that definitely has to pay you in some way to cover your song, every time. And what kind of rights were you thinking that the first person might have? You mean the owner of the copyright published?
the right to record it for money first. That's a guess, I don't want to talk about that.
I don't think so.
Right.
Anybody have an idea on that?
What was the question?
I don't know.
If you're a songwriter and you create a song, and so it's your copyright, does that give you the right to say who first records it for money? In particular, to block other people
Right,
before you
right.
get a chance to record.
That's a good question. I do not know. I think you can say nobody can cover it. And then you cover it, then you open it up to be covered. So I guess you do have that right. You
Yeah.
have moral rights, sort of, to say it can't be used in a porn movie. You know. But behind you, you had an idea on that? Did you have an idea on that? Or?
Sorry, we just actually did this in class, and I believe that if the song is completed, then it can be. But if it's like you and other songwriters coming together to collab, it's really not. Whatever you did at that time doesn't really count because it's not a completed body of work. Yeah,
The copyright's on the fixed.
because that has to be fixed. Yeah.
Did you have a part two to your question?
Yeah, okay, so I do a lot of activity with amateur like stand-up comedy, and a lot of times there'll be free shows and we'll record them. So I'm wondering if, like, let's say my friend Mike is on stage and he goes up and tells a bunch of jokes that I recorded, do I own the copyright in that recording, or does he, because he's the one performing the jokes, even though I'm not sure if jokes are necessarily copyrightable? Like,
They are.
oh, okay, who's copyright in the video?
So let's see, you own the master recording rights.
She owns it.
I think you co-own maybe the master recording rights. He has the performance rights, and he owns the publishing rights.
Well, it's not music, so
No, but it's
It's still the same.
published. If he has a written script, which if it's improv, like I said, then that's a different,
Because
yeah.
most of the time, you know, they'll have the same basic premises and the same kind of like setup
But he'll do a little
punchline
different
attack.
every time.
Yeah, but as they go on stage, they rework things and stuff. I'm just curious, like.
That's a good question. I think you might own the master recording rights then.
She does.
Unless, when would it be considered a bootleg? If he told you you couldn't do it? I think he might have to give you permission for him to use his performance rights.
Yeah, I was going to say that. Can't you just nip that in the bud in the beginning? For example, it sounds full release and pretty much have verbiage that says, hey, since you're performing here, any recordings will be used.
I think he has to give you permission.
Right, I mean, you can nip that in the bud.
He can deny you permission, that's for sure.
Right.
Yeah.
Yeah, I'm just curious because
Yeah, I
like
think you would,
a lot of these
because
things
then-
are free, so I don't know if it like makes a difference.
That's a good
to the
question.
image.
Because you own the tape, you brought them equipment.
she'd have a license probably to the material because if he knows he's being recorded.
Ideally, when he gives you permission, yeah, he's giving you a license.
Yeah, I mean, we just kind of like blanket record things just in case anyone wants a copy in the future.
Right.
And like me and my friend, we just keep the copies on our hard drive. So if anyone comes to us and says, hey, can I have a copy of my set from November 14th?
Right, right.
We go, okay, sure. But like, otherwise we kind of keep them.
Right.
And like, I generally just give people the copyright and or I'll just put a little copyright notice with their name on it because,
Right.
you know, we're not making any money off of it, but some of these people are starting.
Permission with an unwritten license at this point. Yes.
I want to go back to logos. Like we're starting out, so I wanted to know what would be better, either copyrighting the logo or trademarking the logo, which would be.
It's definitely being used as a logo for a business. product. Unfortunately, trademark is a little more expensive. I would wait till it's used in commerce then. I think you said it was on the business card, right? I think that counts. If it's been handed out to potential customers that's used in commerce, it's really a trademark. Yeah. The artist that created the logo only holds the copyright to it. So there's some overlap.
I'm the artist.
Okay. You own the copyright on it.
Oh, okay.
Yeah, already. And you own a common law trademark, essentially, in this territory.
Oh, okay.
But I would recommend registering a trademark if it's you want to grow a business.
But you had mentioned that you have to do different trademark, different register of the
Right.
trademark.
So if you have one single thing you're going to do, I'm just going to sell T-shirts, then you only need to pay the fee once. But if you're doing wildly different things, then in reality you're supposed to pay for each one. Or you can start with one and not be protected for the other, and essentially nobody's probably going to infringe you if you own one of them. But it's a risk.
Does that apply if it's a service-based business and you have different types of services?
Yeah.
So the services are all interrelated?
Yeah, it's the same, a product or a service, yeah. So if you have a service and you can describe it in one thing, I do advertising services. So even though you might do lots of different kinds of advertising services, I think that'd be one fee. But then if you sell magazine, this and that, it depends. You can look up online at the USPTO.gov, you can look up the classifications on how they're described. And they have them divided into the goods and the services. And you can see where yours would fit.
Pertaining to her question, you're an artist.
Yes.
So what if I came to order a logo from you? I gave you the idea of what I want for the logo, and you fix it up for me. Who owns it?
So
I pay you.
in a perfect world, you would have a written agreement that says, I'm paying you. You're going to do it for me, but I'm going to own the contract, I'm going to copyright, and I'm going to get a trademark. And they're saying, yes, I'm just doing this as a work for hire.
So
If you don't have it in writing, she might be able to argue, this was a piece of art, you're just using it for this, you didn't have a clear understanding.
Because she fixed the idea.
I gave her
As
the
the
idea.
artist owns the copyright until it's transferred. There's a default assumption of work for hire in most cases where the copyright ownership transfers to the person who paid for it. But that doesn't always happen.
So when I get a receipt,
It doesn't.
that I paid.
No, that doesn't. No, a receipt would not be a written contract to say who owned the rights. David, you have something to add?
Just to clarify something too with the work for hire. So the default is in an employment situation, definitely,
That's a
if you're an
good point.
employee, the default is that the employer is going to own it. There is a circuit split right now, but what that means is that different parts of the country fall different ways with when you're not an
Or
employee.
a contract.
And in where we are in this part of the country, if you do not have it in writing ahead of time, and I know that was part of your
Yeah,
question
yeah.
before, it's not valid. You cannot do a work for hire after the fact. And that's true in
That's good to know.
California, in Illinois region, and down here.
So
It has,
after the fact, you didn't have it in writing,
you have to do an assignment. You cannot, it's not a work for hire anymore.
so the
Unless it's an
artist would
employment
have to
situation.
agree to assign it to the person who paid.
So that would be,
It's not right.
that's the worst case scenario.
Yeah.
Yeah.
So that effectively means the default is it's not a work for hire.
In Georgia, apparently,
If
If
you
it's
don't
not
have
in
any
writing.
kind of agreement.
So there's no presumption that. it's
unless
a
they're an
work for hire.
employee.
If it's an employee, there's
Unless
probably
it's
still the
their
presumption. It's
employee.
probably still there.
And then I had the issue at work where they were a contractor, like a consultant. Like, is that an employee or not?
That's where there's a case, it's called the CCNB factors. There's a case that goes through 13 factors that the court's supposed to look at to determine, are you really a contractor, even if we call you a contractor, or are you an employee? And one of which is who paid for the materials. It's one factor.
What case is that?
Like she was asking who paid for the receipt.
CCNB versus, I believe,
You can also find that in the restatement of torts, 3D, the factors that the court goes through.
yeah.
to the county website. So you could also go through the restatement of torts to find out what the court goes through when determining someone's an employee or independent contractor.
Yeah, there's like a list.
There's a list.
Sometimes called the CCNB factors, sometimes called the Reed factors.
And
All right,
restatement of
I'll look
torts
up
3D.
CCNB. Thank you.
Yeah.
So Dave, just to clarify, for a work for hire, it has to be previous and in writing? It can't be a
Yep.
previous oral agreement?
No, it has to be in writing. The statute says it has to be in writing, for, unless it's an
If you have an oral
employment.
agreement, everyone agrees.
Then it's not going to be a problem
It's not
anyway.
It won't be a
I
problem
mean, nobody can force you to have an agreement other than what the two parties want.
until you make more money than they do.
Yeah.
Right.
And money always
The,
rules.
the writings are always written as both, though. It always says it's a work for hire, but the standard clause is boilerplate. It's a work for hire, but if it's not a work for hire, then you're going to assign it.
Did you hereby sign it, agree to sign anything I ever want you to sign, then sign it? Yes.
Hi, I'm so sorry. I have so many questions. And I came a little late, so I hope, sorry in advance if this is some stuff that you went over. Okay, so I have questions about recordings and written composition. So if I have like a rough demo and I have like, like the written lyrics and the song, like songs, not necessarily sheet music, but just like the written songs with the chord progression, I need to know, I was wondering what exactly out of all those options, because I've copyrighted my stuff before and I think I did it wrong. So I want to know once and for all, like when you do like a rough, I guess you could call it like a rough draft of your work, but it's completed, what is it called when you go on under the website?
I have no idea. Does anyone know? I've never dealt with that. A rough draft, trying to copyright a rough draft?
Yeah, kind of like a demo, like you have the song completed, but it's not the it's not the final recording that you're gonna.
So you own the publishing rights when when you've written the lyrics.
Yeah.
I guess you own the copyright to the lyrics. When you finish writing the music that goes with it, you own the composition rights. I don't really know what if it's until it's fixed in a tangible form.
Yeah.
It's not copyrightable under the federal law. I don't know.
She's got it on tape or even on a hard drive. That's
I mean, and then
fixed.
if it's fixed in a tangible form and it's a version, you own the copyright to that version.
Even if it's an acoustic version. Okay.
Yeah, it's a version of the song, I guess.
Okay, and even if I guess then my question is, so I've copyrighted some of my stuff before, so even if it's copyrighted wrong, like I've submitted it, and that stuff will still be there. I mean, like I'll still legally
What do you think you
protect
did
it.
wrong?
I think I accidentally I copyrighted it under final recording, and I don't want to use that as like
Right.
my final
I think
representative.
that's fine. That's not wrong. I guess you can have multiple versions. You can have
Okay.
multiple final versions.
Okay.
I think that's fine. Yeah.
And then I guess my other question is, when I do finally have my final work done, like the final recording and squeaky clean is exactly how I want it, do you know what it's called? I think it's something like final recording or,
I've never done that on the website.
yeah. The website's just so confusing. I guess I have like website questions, so. Okay, well I think that's cool.
Sorry. I've never recorded, never filed for the copyright for a musical piece online. But does anyone know?
The only observation I might make about copyright.gov is either there's some nuances I don't know about, or they don't get very exacting with their use of the creation date versus the published date,
Well, that's interesting.
which I understand there is. So, like in particular, I've read this several times in the copyright notice, they say it's the year published, not the year
Yep.
copyright. So my advice from other people has been, if I wrote something like say 10 years ago, never registered. Now it looks like it might be pretty good. So I go to register it now. The advice was still put the date of creation as 10 years ago. So that's a copyright fixed date different from the publishing date. But if you read it through all the stuff on the website,
Right,
it's
right.
so
So I don't really know what counts as publishing in that case. If you've written a piece of music, you've never shared it with anyone.
well, I may have performed it, but
Okay.
as I understand it, performing it is not
No,
publishing.
that's not published. That's interesting.
I have a related question.
Okay.
You're talking about publishing. What defines when a painting has been published? They ask you if this work has been published
Right.
before it's been copyrighted, but
That's a very good question.
I
David,
mean,
do
it
you
sounds
know?
like it's not just displaying it in public.
I think it is.
Mhm.
I think that counts.
You think that counts?
Yes.
I thought I read something that said that.
I don't know how else you publish a painting.
Right.
I mean,
Publishing is sort of an interesting word because it's defined differently in different parts of law. So for defamation purposes, it's telling your neighbor something about the other neighbor is publishing for in that context. In copyright context, I believe essentially one public display of visual art would be putting it out there to the public, and at that point that's a
That's
form of
what I thought was
publication.
publishing. I know for sure that you don't have to publish a picture of it in a magazine to
Right.
get the copyright, so it can't be that.
Right.
So I don't know what else would count as publishing other than and I don't think it has to be a very public display. I think it can be just showing it to someone else.
Putting it on a website counts publishing?
Absolutely.
Yeah.
I mean, that can be your default. I absolutely put it on my website,
Right.
even if nobody looked at it.
And it doesn't have to be displayed for sale.
No.
It's displayed.
Yes.
I have a second question. In regards to trade name / business name, if you file as a legal entity, does that count as establishing a trade name or business name, or is there some other process?
So in Georgia, you can file as a, say, a corporation or an LLC. That is your corporate business name. I think in some counties and states, you can also file it as a business name, but I don't think you need to if you've already registered as a filed, like with the Secretary of State business name. That's my understanding. Does anyone know? Otherwise, I don't deal with that.
You file with the
particular-
clerk of superior court in various counties.
In various counties, I know you can
Yeah.
file as a trade name, but I think if you already own, for all of Georgia, if you already own Heather LLC, I think if you, to get a business license, you have to pay the county, but I don't know if you have to buy a trademark name.
I don't think you have to buy it, I think you just file something
Okay.
with it, but check with your, whatever county you're
Yeah,
in,
clerk
check
of
with the
superior
Chamber of
court.
Commerce or the clerk of
That's a
superior
good
court.
idea. Yeah, clerk of superior court for their county. But I don't think it's required to say that I own the name. That would be required to practice business in that county, to be a licensed, registered business in the county. So you could get a trademark on a name and never get it as a corporate name. Just having a corporate name doesn't necessarily keep other people from using it as a trademark.
So that was a clerk of.
I guess that's it. One more?
I have one more. I guess I guess this can be an open question. Maybe has heard of it, but are you familiar with the Led Zeppelin case that I think has been going on for a few months, where a band that is claiming that they wrote the intro or a part of Stairway to Heaven, and now they're coming back after
After all
40,
these years,
yeah, 30-some, 40 years. Can you speak to that? Are you familiar with that case?
No, I mean, I just saw the news blurb about it like you did. But I know that would be one of the cases where they slept on their rights. It could be argued. I think it's also called a laches defense. It's like, if you had sued me back then, I could defend myself and prove I wrote it. But you waited this long that I don't have access to my notes anymore. But I think they basically have to prove, like we said, they actually copied it. They had access to it, they copied it. That's a tough one. I don't know. Does anyone know?
Well, statute of limitations would probably kick
Is
in.
there,
3-year statute of limitations in copyright.
when they became aware of it. Did they really just become aware of it?
And I think that's one of the issues, right? I think that there's an argument that the statute of limitations doesn't apply.
There is a circuit split on statute of limitations too. Copyright is fraught with circuit splits, and yes, it depends on where they bring suit.
There's an interesting, right now, the Copyright Act says that for 35 years, the old act was 35 years, and if you gave notice 2 years before that was up, you could get your copyright back. So I read an article like Bruce Springsteen, Donna Summer, I don't know, the states are trying to give this notice now that all of these things that were 35 years ago are coming up for this, people getting back their copyright that the music studio recording companies own. So, and I think Bruce Springsteen's getting back a lot of rights to songs,
It's the current act, actually.
current act, so the 35 years. So I thought that was interesting.
Yep.
You can look at Google Bruce Springsteen.
Went into effect in 1978, so 2013 was the first year where people could start.
And you have to give 2 years notice, which is very strange. So some people are complaining they learned about it too late. But that's all. Thank you for coming. I hope I helped. I think we're gonna